Hello everyone, welcome to lesson 3 in your Aylsham High Citizenship course, and today's lesson is called What is Law? There are two types of law that we will look at today. At the top of your worksheet it asks you to write a definition of each of the two types of law, and the first one we're going to look at is called common law. Now common law is all about what we have seen, and by that we mean it's law based on what's gone before. Prior to 1066, the UK had no coherent legal system. And William the Conqueror, as some of you have probably done in history, you'll know that he was the first king to unite the customs and traditions and create courts and a legal system that was common to the whole country, hence the term common law. The decisions of these courts were recorded and published, and it therefore became possible for the judiciary to look at previous decisions or precedents and apply them to the case at hand. So common law, therefore, means to use precedent. You look at what has gone before, previous decisions. Judges are therefore extremely powerful in common law because they interpret the law based on what has gone before. Now for the second type of law that we're looking at today, and this is civil law. So whereas common law is what we have seen, civil law is what we have written. So by contrast to common law, civil law can be traced back to Roman law. And civil law involves a codified system, and that means a written system. If you hear the word codified, it means written down. So civil law involves a codified written system of rules used by courts to decide what is right and wrong. Civil law systems place much less emphasis on precedent than they do on the codification of the law. These codes establish legal procedures, punishments, and what can and cannot be brought before a court. In a civil law system, a judge has less power. All the judge does is establish the facts of a case and apply remedies that are found in the codified law. As a result of this, lawmakers, scholars, and legal experts hold much more influence over how the legal system is administered than judges under civil law. So under common law, judges hold a lot of power. They make the decisions, they interpret based on precedent. Under civil law, judges don't have as much power. They apply what's written down. They have to look at the facts and apply what it says. Okay, so in your workbooks, just make sure you have got a definition written of common law and civil law. Once you've finished that, if you have a look at these three letters, these are the initials of the three branches of power in the UK. So we looked at this about 5 weeks ago, so it was a fair time ago. But can you remember the three branches of power in the UK? They begin with E, L and J. See if you can figure those out. Hopefully you remembered that the answers were the executive, the legislature and the judiciary. So when it comes to laws and how laws are made in this country, laws are made by the legislature. What we're going to do now is have a look at how that happens. So on this diagram, you can see the two houses of Parliament. In red, you've got the House of Lords on the right, and then on the left in green, you've got the House of Commons. And both houses are involved in the creation of laws. So what happens is, at the beginning, there will be a bill proposed for a new law or a proposal to change an existing law. And that proposal or bill is presented for debate before Parliament. Bills are introduced in either the House of Commons, green, or House of Lords, red, for examination, discussion and amendment. And when both houses have agreed on the content of a bill, it is then presented to the reigning monarch for approval. So it will be given to now the King. This approval is known as royal assent, ASSENT. So this approval is known as royal assent. And then once royal assent is given, the bill becomes an act of parliament and it is therefore law. So the bill, as you can see on the diagram, goes through various readings, first reading, second reading. There's a committee stage where questions are asked of people involved. There's a report stage where we get more information. Then there's a third reading. If needed, it follows, if you follow the red path, it can then be passed through to the House of Commons for further study and then back to the House of Lords. But at some point, the bills will go into the middle there, a consideration of amendments, and then they will go off for royal assent. So there are a number of places in which the legislature makes sure that any bills being put forward have been examined properly. Bills can be introduced by different people. The government can introduce a bill to be put forward to make a law. Individual MPs can do it too, or individual lords. And you can also have requests for laws put forward by private individuals or organisations. So they're called private bills, and they'll be requested by organisations if they want to change something in the law, usually to suit their own ends. Public bills are bills that link to the general population, and they're the most common type of bill introduced in Parliament. And government ministers propose the majority of public bills. They usually involve the public's money. They're largely financial, so to do with taxes or public spending. And they're almost always introduced, therefore, in the House of Commons. In your workbooks, there is a box that asks you to explain in your own words how laws are made in the UK. So just take a few moments to do that, write in your own explanation. When you've finished, if you finished before other people, you can have a look at the map that's in your workbook, and there's a task there that says identify some of the countries operating under civil law, they're the blues, and operating under common law, they're the pinks. And then you can have a think about which legal system do you think the green countries might operate under. So looking at where those green countries are, have a look at where you think they might, which law you think they might operate under. If you pause the video here to make sure you've finished the last couple of tasks, and then press play when you're ready to learn about the European Convention on Human Rights. So the European Convention on Human Rights is really topical at the moment. It's been in the news quite a lot lately. And what it is, despite leaving the EU, UK domestic law is still subject to the European Convention on Human Rights. And the ECHR is an international treaty which member states of the Council of Europe have signed, including the UK. The Convention sets out a list of the rights and guarantees, called Articles and Protocols, which the states have undertaken to respect. What this means is that UK citizens, like you and I, have many rights that are protected under the Human Rights Act that was passed in 1998. So let's have a look at some of those rights that are guaranteed for us under the Human Rights Act. And at the bottom of your workbook page, you can add some information into that box based on the next slide. Here are some of the rights that are protected for you and me underneath the Human Rights Act of 1998. Article 2 declares that we have the right to life. Article 3, the right not to be tortured or treated in an inhuman or degrading way. Article 4 gives us the right to be free from slavery or forced labour. Article 5 gives us the right to liberty. Article 6, the right to a fair trial. 7, the right not to be punished for something which wasn't against the law when you did it. 8, the right to respect for private and family life, home and correspondence. 9, the right to freedom of thought, conscience and religion. 10. The right to freedom of expression. 11. The right to freedom of assembly and association. If we pause there for a moment, that particular article is one that is potentially under threat. At the moment, the government is considering trying to pass a new law. So there's a bill being discussed about limiting the rights of individuals in the UK to freedom of assembly and association. It's linking to that article. Have a look at some of the others and make some notes in your workbook about the rights that are protected for us under the Human Rights Act of 1998. So what does the Human Rights Act mean for you and me? First, it means we can seek justice in a British court because it incorporates the rights set out in the European Convention on Human Rights into domestic British law. So this means that if your human rights, your fundamental human rights have been breached, you can take your case to a British court rather than having to seek justice from the European Court of Human Rights in Strasbourg in France. It also means that public bodies must respect your rights. The Human Rights Act requires that all public bodies like courts, police, local authorities, hospitals and publicly funded schools and other bodies carrying out public functions to respect and protect your human rights. Excuse me. It also means new laws are compatible with convention rights. In practice, it means Parliament will nearly always make sure that new laws are compatible with the rights set out in the ECHR. Ultimately, Parliament is sovereign and it can pass laws which are incompatible, but generally they're required to be compatible. And the courts will also, where possible, interpret laws in a way which is compatible with convention rights. So what does the future hold? Well, the Human Rights Act gave judges new grounds on which to overturn the decisions of public authorities, and the Act gave UK judges the authority to review whether public institutions were complying with the rights set out in the ECHR. In recent years, we covered this a little bit in Lesson 1, the claim has regularly been advanced that judges have been overreaching into matters of politics and deciding cases on the basis of whether a decision corresponds with certain values. In 2021, the government were considering removing the power of the ECHR so that judges would not be bound by it. So that was from a Times article in 2021. This year, the conversation has continued with both Braverman and Sunak talking about leaving the ECHR. So we would no longer be a country signed underneath that convention. Okay, recap quiz just to finish off. So question 1, which of these might be done by a common law judge? Would a common law judge consult a legal document written by legal experts, or would a common law judge read over similar cases and their outcomes? Next question, in which year was the Human Rights Act passed in the UK? Who has the final say over laws written into the UK Constitution? And what is this final say called? Have a go at those, and I will see you in 2 weeks. Well done.